Okay. We had some bad connections, so I had to make sure we're on, but it looks like we're live. So happy Friday. I know I'm very glad to have the end of the week here, and I hope that it's been a good week for you and you've got something nice planned this weekend. I know it's the start of spring break here, so a lot of people may have spring break plans. I wanted to talk today about what should you do if you get served with a lawsuit. So maybe, in family law, a lot of times people may be expecting it, especially if you're dealing with a divorce, if you know things are going badly, if you're living in the same household and it's tense, or you've had the discussion about, it's time that we end things and let's, do what we need to do to end things. So sometimes it's not a surprise, sometimes it is a surprise. And so if you get served with papers, the way that works is a private process server or a constable will come. They can come to your house, they can come to your job, they can come wherever they can find you. So they don't have to come to a particular place, but if they know that you're going to be at a particular location, they can find you there and they can give you the papers, and that's what it takes to serve you. And so then what are your next steps? I would say your first step is read through everything that you've been served. Now, whenever you get served with citation, there's going to be a cover sheet on there that's prepared by the district clerk. And I'll be honest and say, as an attorney, I don't read through every word of that because I'm used to seeing them and they are all the same. And so it will give you instructions. And the most important thing that it will tell you is when your response is due. So if you're going to file a response, it's due almost every time, and in family law, pretty much every time it's due the Monday following 20 days. So you count out your 20 days, and then the Monday at 10 a.m., the next Monday after you count 20 days at 10 a.m. That's the due date on your response. And so you want to read through that cover sheet on that citation. It'll give you those instructions. It should have on there, the process server, they'll have a copy that they keep that they'll fill out when they served you and where they served you. Sometimes they'll put that on your copy, sometimes they won't. You may want to make a note of it, because when you come see me as the attorney, I'm going to ask you, when did you get served, so I can count out how much time we have left to get that response in. So read through that first. Then you're going to want to read through the petition. Find out what's in there. What does it say? What are they asking for? Now, again, this is the hard part because they're going to use a lot of legal terminology. There's going to be things that you don't understand. That's okay. Hopefully, you can at least get the gist of what it's about. So, is this a petition for divorce? Is this a motion to modify? Are they asking to modify the child support? Are they asking to modify the custody? So, read through there and see that. The other thing that you're going to want to look for is, are there standing orders that are attached to the back of that petition? Here in Brazos County, all of the courts have adopted, or the family court, we don't have exclusive family courts. We have district courts, county court at law, but all of those courts have gotten together and they've said in their family law cases, we're going to have these orders go into effect on every case from the beginning. Now, it's mostly common sense stuff. And so what I would like to call it is kind of a Band-Aid of things that you can't do while the case is pending. So just as an example, you can't harass the other party. You can't call them 50 times in a row. You can't call them late at night. You can't make threats. You can't threaten to hurt them. You can't threaten to put all their property out on the lawn and light it on fire. You can't actually follow through with any of those threats, so you can't put all their property on the lawn and light it on fire. You can't cancel, if it's a divorce, you can't cancel any like credit cards that are in both of your names, bills. I can't cut off their access to funds. So there's going to be a list of rules. And so that's, again, like I said, that's the second thing, or the third thing really. So we want to look at the citation, we want to look at the actual motion, and then we want to look at those standing orders to see what's in there so you know what rules you're expected to abide by. And the reason that's really important for those standing orders is as soon as you're served, you're expected to abide by those rules. So if you don't read them, and let's just say, for example, that you share a credit card with your husband, and you get served and you don't bother reading anything, and you get mad and you go cut off that credit card. Well, just because you didn't read it, that's not a defense. You were served with notice of those rules, and so you could be found to be in violation of that, and there can be consequences to it. So it's important to read through that and understand all of that. Then you want to start thinking about, am I going to hire an attorney to handle this for me? I would strongly encourage that at minimum, you at least meet with someone. Meet with someone that's going to talk through the issues with you. And I've done videos before, I think, about initial consultations. I'll address that real briefly here. I know when I do an initial consultation with someone, I do charge my hourly rate for that. And there are a lot of people that call and they don't want to pay, and they don't understand why they have to pay an hourly rate. The reason I do that is because we sit down in your consultation and we talk about, here's what's been filed. Here's what I recommend. We're going to get into the nitty-gritty details of your case, and I'm going to be giving you legal advice. And so I'm going to be advising you on how I think you should proceed and what your options are. There are some attorneys that do really quick initial consultations, and they don't get into that with you. They just meet with you to see if you're a good fit, which that's an important part of hiring an attorney, is knowing if you get along with that person and you trust them and you feel comfortable that they're going to handle your case well. But you also need to know that they know what they're talking about, that they're going to advise you, that they're going to inform you about how things are going to go, and that they're going to take care of your issue for you. So like I said, I believe that you should meet with someone, at minimum, meet with someone to talk through what the issues are, what your options are, so you understand. And then if you choose to do nothing, or you choose not to hire an attorney, and you choose, let's say it's a divorce, and you decide, look, I'm gonna work with my soon-to-be ex-wife or ex-husband, and we're going to reach an agreement, and then they're going to take that agreement to their attorney, and I'll just won't have somebody representing me. That's your call as an adult. You're free to make that decision, but at least be informed on what your options are. I really can't stress that enough. So that's kind of the basic things you really need to do right off the bat whenever you get served on a case. And that really applies, I would say, to any case, whether it's a family law case or like a car accident case, or any contract case, whatever. Anytime you get served, go through those 3 steps. Hopefully that's helpful, and that's some information for you. If you have any questions, like I always say, put them in the comments. Feel free to type them in here, and I'll address them in videos. I will be at work next week, even though it's spring break. So we'll do some more videos next week, and y'all have a very wonderful weekend. Thanks. Bye.